For those of you who don't know me, I'm Vanessa Antone, NACDL Senior Resource Counsel, and I want to welcome you to this Engage and Exchange, the first of a two-part section for the Busy Lawyer's Guide to Character Evidence and Impeachment, presented by Nevada Federal Defender Rene Valladares. So we are lucky enough to have him with us, not just for this two-part session, but another two-part session. So we're going to have 4 weeks of evidence. Now, because this is such a great, exciting topic, and we have an incredible author with us, we are really encouraging everyone to ask questions along the way. Please don't hesitate to do that. Don't be shy. Put them in the chat, and we will have Mr. Valladares answer those for you along the way. Maybe, you can join in the conversation and follow up on those. If for any reason you have any issues submitting those in the chat, any technical problems, please feel free to shoot me an email and we will make sure your question gets out there. But again, do not hesitate to participate. One other housekeeping note, we're going to be looking at a PowerPoint as well. Our speaker will be spotlighted for everyone, but if you're having a problem seeing it, you can just go up and toggle to the speaker view and also click on hide non-video participants. That will get you rid of any little annoying rectangles of people's names. So none of that is why you're here. I have talked enough, and without further ado, I would love to introduce our speaker. We are lucky enough to have with us today Rene Valladares, who's the federal public defender for the District of Nevada and has been so since 2011. He is also an adjunct professor at the University of Nevada, Las Vegas Boyd School of Law and a part-time instructor at the UNLV Criminal Justice Program. He has lectured nationally on criminal law and criminal procedure issues, including conspiracy law, search and seizure, and the impact of culture on the criminal justice system. He also serves as the Federal Defenders Performance Management Group and Federal Defenders Death Penalty Working Group. His publications include co-editing the first edition of the treatise Cultural Factors in Criminal Defense, which is now in its 4th edition. And we will also say that the series is based on this, this book, which I'm very excited to actually have a visual aid here. And we will have a link to it in the chat. So A Defender's Guide to Federal Evidence. If you haven't checked it out, we'll send you a link to do so. Those are just a few of his many accomplishments. And without further ado, I will turn it over to you to begin. Thank you very much.
Well, thanks a lot, Vanessa. And it's great to be here with everybody. And it's great to work with you, Vanessa, as well as everybody at NACDL. You guys always do an amazing job. So like Vanessa said, basically the idea is to have 4 sessions on evidence. And the idea is that we'll be covering the 2, what's widely considered the most challenging topics in evidence, character and character-related impeachment, as well as hearsay. And then the idea is that today we'll go ahead and cover character as well as next Wednesday. And then the next 2 sessions after that, we're going to go ahead and be covering hearsay. Now, as Vanessa, mentioned, I'm going to go ahead and get my PowerPoint started here. I hope that everybody can see it. I'm going to share screen so everybody can go ahead and see it here. And as Vanessa mentioned, basically much of the lecture is based on the book, A Defender's Guide to Federal Evidence. This is a NACDL publication. You can go ahead and get it at the NACDL website. And all royalties from the book go to benefit NACDL's Foundation for Criminal Justice, a foundation that does amazing work to advance and reform criminal justice. Now, as I said, much of the lecture is based on the book. In addition, the structure of the lecture is in large part based on the book. That is, we'll be talking about black letter law, specifically the federal rules of evidence, the applicable federal rules of evidence. Then we'll also go ahead and talk about case examples, and specifically defense favorable case examples that illustrate applications of the federal rules that we're talking about. And then lastly, I'll try to offer tips here and there along the way, and that's essentially kind of how the book has it structured. Here's my email to any of you that wanna talk about a specific case or have a specific question, dealing with an issue of with an evidence issue. Don't hesitate to go ahead and reach out to me. Oftentimes I'm talking to people about a specific problem they have as far as evidence, or brainstorming a case and all that. And don't hesitate to go ahead and reach out, to me if you'd like to go ahead and do that. Now, a word on evidence. Evidence is hard. I find evidence to be hard, and because of that, I put a lot of time into it. I've tried to, come up with a way to simplify it for myself, my students, my fellow colleagues, and hopefully to you as well. But a knowledge of evidence, there's nothing like a strong foundation in evidence to be able to really advance our clients' interests, especially since prosecutors and unfortunately judges oftentimes either don't know evidence, or prosecutors play fast and loose with evidence. So again, it really behooves us to know evidence and to know it well. Now, focusing here on character, I think that character is really one of the key things in evidence, and especially because the role of character in our criminal justice system has really been a pernicious one. And you go back to like the Salem witch trials, where people were targeted because of because they were quirky or odd or marginal and all that. And typically that's what ends up happening with character, is that those clients of ours that that may be somewhat vulnerable, that may be peculiar, that may be a little strange, they end up getting the hammer or the prosecution. And again, that's one of the reasons why we have to be on such strong guard when it comes to discussing character. Now, let's talk about what character is. The character is actually not defined in the federal rules of evidence, but is generally understood to be a description of a person's disposition or a general trait such as honesty, temperance, peacefulness, and that sort of thing. And in this lecture today, as well as next Wednesday, we will be focusing on character and character-based impeachment. So impeachment based on character. We will certainly talk about impeachment based on prior inconsistent statement, bias, or sensory deficiency. We'll do that next time, but that's going to be less of our focus. Our focus is going to be mostly on impeachment based on character and character traits, past deeds, criminal history, and that sort of thing. Now, let's go ahead and go on to an outline of the specific topics we're going to be talking about in this presentation, and then a little bit about the next one as well. So today we're going to be talking about the propensity prohibition. And whenever you guys see this fellow here, this is a character in the in the Mexican bingo game of Chalupa, and this is a Diablito. When you see this character here in the slide, it's because we're transitioning from one topic to another. So we're going to talk about the propensity prohibition and what that means, the propensity prohibition in Federal Rule of Evidence 4.4a. Then we're going to go ahead and talk about methods of proving character. And then we're going to go ahead and talk about the the very important but very tricky area also of exceptions for the character of the defendant and the victim. And that is the defense is initiating presentation of character of the defendant and the victim. And then, of course, with the tricky part, and that is what the prosecutor can do in turn. Next session, next week, we're gonna be focusing on character of a witness, which is really focused on credibility. And then we're gonna also talk about 404B, the very pernicious use by the government of 404B. And we're gonna also talk about Federal Rules of Evidence 413 and 14, that is similar crimes and sexual assault and child molestation cases. So this is kind of like an outline of the topics we're going to be covering. And again, today we're going to be looking at propensity, methods of proving character, and the exceptions to the propensity prohibition, looking at the defendant's character and the victim's character. So let's go ahead and get started here with the propensity prohibition. Now, Federal Rule of Evidence, states that character is not admissible to prove action in conformity. Okay, and that also applies to other crimes, wrongs, or acts. So neither character nor other crimes, wrongs, or acts are supposed to go ahead and come in to show action in conformity. This is, of course, the propensity prohibition. And, it all, sounds, very much straightforward, and it should be in theory, but, this is an area that does have many, many traps for the unwary, and, and especially for us, for criminal defense lawyers. It's an area where if we're not careful, really bad things can happen. What I'd like to go ahead and do then is get started with the propensity prohibition by talking about a case. This is a defense win, a great defense win in a fairly recent case. And this is the Welsh case. The Welsh case is from the Ninth Circuit. It's a 2018 case, and don't worry, this is not going to be. I happen to be in the Ninth Circuit, but it's just not going to be Ninth Circuit cases, and just not going to be cases about what is in theory a very liberal circuit, although it's not necessarily that way. We're going to have cases from all over the country in the many examples that we'll talk about during this presentation. But here's what happened in Welsh. Welsh is a great case that can really help to illustrate the propensity prohibition, and can also, illustrate the type of shenanigans that the government engages in as far as character in these cases and many of our cases. What happened in Welsh is that the defendant was charged with 2 counts of murder, specifically 2 counts of murder of a federal employee. In addition, the defendant was charged with counts of using a firearm in relation to a crime of violence resulting in death. The case ended up going to trial. The defendant was convicted. The defendant ended up receiving, in way of sentence, 4 consecutive life sentences. Now, what happened here is that this case arose out of the death of defendant, the shooting of defendant's co-workers at a U.S. Coast Guard antenna maintenance facility in Anchorage, Alaska. Now, the government at trial presented during their case in chief evidence evidence by an expert, a psychologist, on targeted, intended workplace multiple homicide violence. That was the subject matter of the evidence presented by this psychologist. This psychologist was an expert on targeted, intended workplace multiple homicide violence. And what the expert talked about specifically was the expert went ahead and the expert gave a profile as to what is the typical individual that commits this targeted, intended workplace multiple homicides. And the profile as presented by this expert was as follows. Now, according to the expert, individuals that committed this type of murder typically were, number one, male. Number two, they were typically pathologically narcissistic. Typically, they had an inflated view of themselves. They typically would go ahead and perceive any slight criticism as being very wounding and very challenging, I guess, to their self-image, and any type of criticism, especially like workplace type criticism, would cut very deeply for this kind of person, and that this type of person would convert a perceived grievance to anger, and then would start fantasizing about resolving problems with violence. I mean, to me, it sounds like a complete stretch, and it sounds like the methodology and basis of the opinion of this expert were way off. And it seems like they were, certainly something that can be challenged under Federal Rule of Evidence 702. But that would be the subject of another presentation. That is what the expert testified here. Then what the government did is that, the government thought they were being very, very sly and about things. They did not have the expert say that Mr. Wells fit a profile or anything like that. Instead, they had the expert testify. The expert gave the profile that I just mentioned. And then what they did is that they had lay witnesses, individuals that worked with Wells and knew Wells, testify about how Wells was. And then what they did is that they explicitly invited the jury to draw a comparison between what the lay witnesses have testified to and what the expert had testified to. Specifically, the lay witnesses testified that Wells had been a disciplinary problem at work. For instance, because of the disciplinary problems, Wells had been prevented from attending some important conference in that field of work. Again, what these people did is that they worked at some kind of antenna substation, and the victims, however, were allowed to attend this conference that Wells was prevented from attending because of his problems. So like I said, what the government did now is that they invited the jury to draw a comparison between what the lay witnesses had said and the experts. And of course, the subtext was for the jury to go ahead and draw a comparison to see if Wells matched the bill. And of course, Wells did. And the government argued, of course, that that this was not in violation of the propensity rule because the expert was not going to give an opinion on how the characteristics applied to Wells. Instead, that's something that the lay witnesses were going to go ahead and do. So so of course, what happened is that the defendant ended up, getting convicted at trial. So let's see how things played out on appeal, and let's see what the Court of Appeals ended up doing in this case here. So let me one moment here. So what happened here is that the Ninth Circuit reversed. The Ninth Circuit reversed and remanded the case. And the circuit basically, said that the government, in this case, while the government argued that it was not presenting, propensity evidence because it did not have the psychologist make the match and that sort of thing, the Court of Appeals said that this was indeed propensity evidence, that it amounted to nothing but, punishing this individual for where they were, not what, for what he did, for the way that he was, rather. And now here, what the government also argued is that the defense had opened the door to this type of evidence. So the government initially said, oh, that's not propensity evidence. Then the government said, well, if it is propensity evidence, then the defendant opened the door because the defendant relied on his history of nonviolence and peacefulness, okay? And, and if that's the case, as we will be seeing in a few minutes, if the defendant opens the door to that, then, then certainly that could be very problematic. But the circuit didn't buy that argument. The circuit didn't buy it because the government presented the psychologist's testimony in their case in chief. So, so the government's reliance on, well, the defense, opened the door because they relied on the defendant's nonviolence and peacefulness and all that, and they made that an issue. That was really a spurious argument. That was a misleading argument and a disingenuous one, because the government actually presented all this expert testimony and the profile testimony in their case in chief, not in rebuttal, not rebutting, something that the defendant had, put on the table and consequently had opened the door. So the Ninth Circuit here said, no, this is, clear propensity evidence in violation of 404A. In this case, the value of the evidence, the probative value of the evidence was substantially outweighed by any prejudicial impact it may have had, and consequently, the court went ahead and reversed and remanded. And of course, a takeaway here is to always be on guard for the government trying to sneak in, this kind of evidence, for the government, trying to argue that they're bringing it in response to us opening the door. And another takeaway is to always keep in mind the importance of 403, that it is, the substantial, prejudice outweighing any probative value of the evidence. Now, I mentioned opening the door, and that's going to be a recurring theme in this presentation because we see it all the time in this kind of cases. And if we are not careful, and we open the door, then really bad things can happen. As I said, we'll see it time and time again in the cases that we talk about, and as we advance in our discussion here of Rule 404A. Now, and one of the main areas in which we got to be very careful about opening the door is when we're running an entrapment defense. This is a very popular defense. I've run it many times, and it's a defense that oftentimes is the only defense that we got, and we got to go ahead and use it. But as we all know, we have to go ahead and be very careful about opening the door. This case here is a great example. This is the Roper case. This is one of those, cases where, the defendant got an unbelievable amount of time for, distribution of, relatively minor amounts of cocaine base and conspiracy to distribute. The defendant in this case got 262 months. And what happened here is that the case went to trial. The defendant testified, and the defendant testified here that CI, there was a confidential informant involved here, that the CI persisted in calling him multiple times a day. The defense testified that he resisted, that he wanted nothing to do with selling drugs, wanted nothing to do with getting involved with drugs, but that here, the CI persisted, the informant persisted, and that finally the informant went ahead and overcame the defendant's will and pressured the defendant to go ahead and sell drugs. The defendant also testified that he had never sold drugs before. Okay, so again, right then, we're setting it up in a manner where the government can very easily come here and argue that the defense opened the door, and in fact, that's exactly what happened. So what happened here is two things. One, the prosecution went ahead and crossed the defendant on a prior instance of dealing in marijuana. So that was the first thing. The second thing is that the prosecution also presented extrinsic evidence. That is, the prosecution went ahead and presented an agent that testified about the defendant selling drugs to this agent on a separate occasion than the one that they had crossed the defendant on, and the ATF agent went ahead and talked about the defendant selling him drugs and all that. Now, here what happened is that the defendant moved for a mistrial. The defendant moved for a mistrial based on the fact that that the prosecution had presented evidence of character evidence of drug dealing and what have you through cross-examination and through extrinsic evidence, and that the prosecution had done it without 404B notice. And again, we'll talk about 404B at length at the next section next Wednesday, which I certainly hope that that you join me as well. But in this case, the Sixth Circuit, this was a Sixth Circuit case, the Sixth Circuit disagreed. The Sixth Circuit said that the defendant had opened the door, and that here that the defendant had opened the door to both being cross-examined regarding the one instance of drug dealing, and then to the extrinsic evidence of drug dealing through the ATF agent, a separate instance through that agent. So in essence, basically the circuit concluded that in this case, the defendant had opened the door through the presentation of the entrapment defense. So again, something that we need to go ahead and be very careful about. Now, this also, is the case when it comes to impeachment. Okay, we got to be very careful about when our client takes a stand. The client did take the stand in the Roper case, the one that that I just mentioned a second ago. But this is another case where the defendant also took the stand, not an entrapment case. What happened, here in this Beverly case, and again here the court, in this case the Second Circuit, concluded that the defendant had opened the door. What happened here is that the defendant was convicted of possession with intent to distribute, also base. He also was charged and convicted of using a firearm in relation to a drug trafficking offense. Also ended up getting a whopping 260 months. And what had happened is that the defendant testified that he had never possessed a firearm, that he had no familiarity with firearms, that he really had no experience with firearms. He talked about one very limited instance where he was going to be trained on firearms to be a security guard, but that never really materialized, etc. But the bottom line is that he had no familiarity with guns. So then what happened is that the government presented testimony that the defendant, in fact, had gun experience. In fact, the government presented evidence that the defendant had been involved in some shootings in Albany, New York. Now, the court had initially ruled that those shootings were going to be excluded at trial. The court had initially ruled in limine that those shootings were to be excluded, but then, in light of the defendant opening the door, the district court went ahead and ruled that the evidence was admissible. Now, at trial, the defendant argued that this was inadmissible character evidence, that he acted in conformity with the prior action of having been involved in the shootings. But the Second Circuit again said, here, this is the defendant opened the door. Here, this was simple impeachment for specific falsehoods, and that this was not a broad attack on the defendant's character. But again, the key thing, of course, as we all know, is we got to be very, very careful when it comes to opening the door to the character or specific bad acts of our clients. Now, let's go ahead then and talk now about, we talked about the propensity prohibition. We talked about a great example, the Welsh case that exemplified the propensity prohibition. And then we talked about some instances where, different circuits have ruled that the defendant had indeed opened the door. And, and I talked about, how we need to be very careful about that. Before we continue, or before we start with the exceptions to the defendant and the victim, it's very important that we really have a really solid understanding of Rule 405, and that is the methods of proving character, the permissible methods of proving character. Because here, this is an area where the prosecution has no regard for this, and unless we're really on guard for this, prosecution is going to try to go ahead and prove character, even if character can be proven in ways that are impermissible. So let's go ahead and get into this area here. So according to Rule 405, character can be proven in very limited ways. And primarily, what we're really talking about is reputation or opinion. Now, we're going to talk about specific acts in the next slide, but those are very limited instances. Usually, the way that is to be proven is by reputation or opinion, and then also in cross-examination, say assuming that we're the ones that are presenting character, the prosecution can do it on cross-examination of the character witness, and if it's allowed by the court has to allow it. But it's important to note a couple of things. First of all, if the government is doing the cross-examination, say we put character at issue, and we'll talk about the instances in which we have the right to put character at issue, the character of our client or the character of the victim. If that is the situation, we're putting character at issue, and the prosecution then gets to rebut, and we'll talk about what are the instances when they can get to rebut. But let's say that the government gets a right to rebut, so they have the right to do to either present a reputation or opinion witness. But let's say that they are cross-examining the witness that we presented. In order to ask questions about specific instances of the person's conduct, the prosecution has to have a good faith basis for that line of questioning. In addition, they're stuck with what the witness says. They're stuck with what the witness says. And we'll talk about some examples of that as we move along. But again, we already covered situations where we have specific instances of the person's conduct being asked in cross-examination, And an example of that certainly was the Roper case that we mentioned a moment ago. Now, the rule also permits the proving character through specific instances of conduct. This is not again on cross-examination, like I mentioned a moment ago. This is through bringing extrinsic evidence by, say, an agent of specific instances of conduct, and that can only be done when a person's character trait is an essential element of a charge, claim, or defense. So again, like for instance, in the Roper case that I mentioned, the entrapment case, then characters part of the defense. In that case, the government gets to go ahead and do what they did in the Roper case, and that is bring the agent to go ahead and testify as to specific instances of conduct. But this should be the very rare situation, and it should be typically limited in criminal cases to situations like when we're running the entrapment defenses. There's a few other instances, but typically that's where it comes up. This should be a very rare instance. The run-of-the-mill presentation of character has to be under the rule by reputation or opinion evidence. Okay, so then let's go ahead and get into the very important topic here of exceptions to the propensity prohibition. And this is when we, the defense, generates the presentation of character. And then the government has the right to go ahead and at that point also rebut. So again, these are exceptions to the propensity prohibition. And basically what we have is we got 6 different ways that this can end up playing out under the rule. And the first one is evidence of when we put forth evidence of our client's good character, okay? So we do that. That's the first exception to the propensity prohibition. And then if we do that, the government has the right to rebut. And I'll go ahead and give examples illustrating each one of these instances here. Now, so we have evidence of the defendant's good character, the government's right to rebut. The third is when we put evidence of the victim's character, that is negative evidence of the victim's character, oftentimes in the way of evidence of the victim being violent and that sort of thing. But it can be other things too, as we'll talk about later in the lecture. Then now, if we go that route, and if we in fact present evidence of the victim's character, then the government has the right to go ahead and rebut, and the government has the right to rebut that in a couple of ways, which we will look at shortly. Another way that this manifests itself, and that is character coming in despite the prohibition against propensity evidence, that is another exception to the propensity prohibition, is the government's right to rebut evidence that the victim was the first aggressor, okay? That's another way that this comes up, is that we present evidence that the victim was the first aggressor, then the government gets to go ahead and present evidence that no, the victim was indeed peaceful and that sort of thing. Now, another area that we're going to go ahead and cover is the prohibitive use of victim sexual behavior or disposition when we're trying to go ahead and prove up the victim's character. So there's a very important prohibition on victim's sexual behavior or disposition. But more importantly for us, there are exceptions to that prohibition that are important. And we'll talk about some cases illustrating that and helping us understand how we can go ahead and maximize the use of those exceptions in favor of our client. Now, so let's go ahead and look at the first here. That is evidence of the defendant's good character. And this is what is commonly known as the mercy rule. Okay, this is commonly known as the mercy rule. The federal rules time and time again disadvantage our clients, systematically disadvantage our clients. Now, this is one of the few areas where it appears, at least, it appears that the rules advantage our clients because we do have the right to go ahead and make character an issue in a case, the character of our clients an issue in the case. This is an area, however, where a gift horse has to be looked at very much in the mouth. You really have to look at the mouth of the gift horse here because there are very clear potential traps with this rule, and we'll cover them. And of course, that is the fact that the government gets to rebut this. So once we go this route, the government gets to go this route as well too. Now, here we have the right to go ahead and present evidence of our client's good character under the rule, under 4.4a. Now, that has to be a pertinent character trait. And a pertinent trait is being law-abiding. That is a very, very general trait. But let's say, for instance, this case here that I got, the Angelini case. And what happened in that case, this is a First Circuit case. In Angelini, the defendant sought to have 3 characters testify that he was a law-abiding person. The district court, however, refused to allow him to go ahead and present that evidence because the court believed that being law-abiding was not relevant to the case, that it was immaterial, that essentially who cared? So the district court refused to go ahead and allow him to present that. The First Circuit concluded that the evidence should have come in, that the evidence of being law-abiding would tend to make it less likely that the defendant would have knowingly broken the law. This is something that basically applies in any case. So the circuit reversed and remanded for a trial. Now, the court here noted that evidence of, say, for instance, of the defendant being a good guy, that was too general, okay? But that something like being law-abiding was a specific trait that was not too general and was absolutely material to the case. Because again, that would make it, according to the circuit, less likely that this individual would break the law. Now, this certainly appears to be appetizing, and it appears to be something that we should be using, and appears to be something that that we should really consider using in our cases. And of course, it's true. The problem, of course, is that the government gets to rebut that, and not only that, when you're talking about being law-abiding, this is a very broad trait, and and the government could bring in a bunch of different evidence to show that no, in fact, this guy is not law-abiding. So it is a trait that while certainly we can bring in, is something that we have got to go ahead and be careful about. Now, what are other traits that are pertinent? Well, I mean, it totally depends on the case. But you have traits such as peacefulness if the case involves violence, honesty if it involves criminal intent, or if it involves deceit, for instance, truthfulness if the defendant testifies. Now, whenever a witness testifies, whether it be a client or not, truthfulness is an issue. And in fact, that is a one character trait that for a witness can be attacked under Federal Rule of Evidence 608. We'll talk about that at the next presentation. And of course, the Defender's Guide in my book covers that at length, how truthfulness is the essential character trait for a witness, and that is always at issue. If a crime involves one that involves, drug use or alcohol, whatever, abstinence is going to certainly be a character trait that is an important one, a pertinent one, and that it can be made an issue. We can make it an issue. And again, according to Angelini, the issue is that a pertinent trait is a relevant trait, an important trait. That's basically what it is. But again, the trait, if we want to make a trait, if we want to put a character trait of our client into the equation, it's got to be a pertinent trait. And it's pretty easy to come up with ways in which we can justify that particular trait is pertinent to the case. Let's go ahead then and here talk about a case where the defense puts this into evidence, and this is the John case, U.S. versus John. This is a Fifth Circuit case, and here what happened is that the defendant was convicted of 2 counts of sexual contact with a minor after engaging in sexual contact with allegedly engaging in sexual contact with his 11-year-old foster daughter. Now, what had happened here is that the foster child had alleged that the defendant had sexually assaulted her on 2 separate occasions. Now, here, the defense strategy was such that the defense was going to argue that the child had fabricated both instances, so she would be released from that particular foster home. Apparently, the child felt that she was getting disproportionate share of chores at the household and that sort of thing, and because of that, wanted out of the household. And it seemed like she had mentioned to a friend that that she wanted out, and the 2 of them had concocted the story that that the defendant had assaulted her so she could get out of that house. At least that was the defense theory. Now, so the defendant here offered opinion testimony that he had a good marriage, that he was a good parent, that he had never been accused of sexual misconduct, and that he had a good reputation for sexual morality in the community. Okay, so those are traits that through different witnesses, the defendant put in question. The defendant took advantage of the mercy rule and presented these traits as supporting his position that that again he was an upstanding member in the community, that he was a good husband, a good father, and had a reputation for being an upright man, and had a reputation for sexual morality. Okay, so the problem here is that the trial court refused to give a jury instruction dealing with character, the character that had come in. The defendant wanted an instruction that would instruct the jury that you can take into account this evidence here, this evidence of good character in making your decision. And the district court allowed the evidence of character, but denied the evidence of but the court denied the evidence of the jury instruction. So then what happened here is that on appeal, and let's look to see what the appellate court did in this case. And in this case, the Fifth Circuit concluded that the district court committed reversible error by failing to instruct the jury that it could consider the evidence of good character. In this case in particular, the Fifth Circuit noted that there were no corroborating witnesses to the child's accusation, and the guilt hinged exclusively on credibility. And the circuit noted that the defendant's theory was that he didn't commit this crime at all, and that the character evidence could create sufficient reasonable doubt to go ahead and lead to a not guilty verdict. And the fact that the district court failed to give a jury instruction instructing the jury that they could go ahead and take a look at that evidence, the character evidence, was basically dispositive and required a reversal and a remand. So again, in the right case, this kind of character evidence can be, can really be critical, and coupled with an instruction, it can get us what it is that we need. Let me go ahead and talk about another case here that's a very interesting case. And again, I'll pause to, just to make sure to remind everybody that, should you want to talk about a case, if you have a case that you want to brainstorm and all that, don't hesitate to go ahead and reach out. I'll be more than happy to talk to you about it. I do that, with a lot of frequency. I do it oftentimes, a couple of times a week. So let's look at this case here. This is a Fourth Circuit case. This is a great case, and again, that it illustrates that you can use the mercy rule to the advantage of your client in the right case in ways that are very creative. And that's one thing that I love about defense lawyers, about you as my colleagues, is that we can be very creative about things, and this is a very creative display of the mercy rule. So let's look at this case here, and what happened here is that the defendant arrived at North Carolina's Piedmont Airport, and he was going to fly to Orlando. He was going to go ahead and fly there to a relative's wedding. Now, at the ticket counter, he was asked if anybody, like standard questions that that we're all asked at the airport, and whether anybody had given him any firearms or bombs or anything like that, and he said that an Iraqi or Iranian man had asked him to carry a bomb, and that he had put it in the luggage. Well, of course, the ticket counter folks freaked out. They immediately took him to security. Security then questioned him about the bag, and he thought that the thing was still a joke, and he told the security personnel that the bag only had explosives. That's the only thing the bag had, explosives. Now, of course, as you can imagine, the statement created a cost and evacuation of the whole flight concourse, and led to the closure of the concourse and to pandemonium. And of course, the authorities had to be called in. They had to go ahead and destroy the bag, et cetera, et cetera. Now, at trial, because the defendant was charged with statute that made it crime to even joke about this sort of thing, or not to joke, but to go ahead and make statements dealing with having a bomb in a plane, with making false statements about placing a bomb in a plane. This is the Bomb Hoax Act, which requires willfulness or maliciousness as mens rea to violate the statute. Now, so what happened here is that, at trial, actually, one of the airline employees testified that the defendant was like chuckling and laughing when he was talking about, the bomb and that sort of thing. And in this case, what happened here is that the defense wanted to present evidence that this defendant was a jokester, a prankster. The district court barred him from doing it. And what happened is that the defendant went ahead and did a full proffer, in which witnesses testified on the record to preserve the record that in fact the defendant was a jokester, was somebody that was a prankster and that sort of thing. So then the district court, however, denied the evidence. The case, the defendant ended up getting, found guilty, and on appeal, the Fourth Circuit ended up concluding that the court erred in excluding the evidence that the defendant was a jokester or a prankster. The Fourth Circuit concluded that the evidence of the defendant being a jokester, a prankster, would have negated maliciousness, which again, this particular statute required willfulness or maliciousness. And according to the Fourth Circuit, the evidence that the defendant had proffered would have gone directly to that material point. So the circuit ended up reversing and remanding the case. A really neat case, and a case that illustrates again that you can use this character evidence in very creative ways. This is again when we get to go ahead and present evidence of character of our clients. Now, let's go ahead, however, and talk about the dark side of this. So you got a mercy rule. The mercy rule is great, and in theory, it's a great thing for our clients. As I said, it's one of the few instances when you can say that the federal rules seem to go ahead and favor our clients. Although again, that can be very dangerous, as we'll see now, because the federal rule gives the prosecution the right to rebut if the defendant introduces evidence of their character. So let's talk about this. Let's talk about the issues that come up dealing with this. Now, so the first issue is that it has to be for the same character trait raised by the government. And this is something that is a very important thing, because oftentimes what would happen is that we present character evidence under the mercy rule, character evidence of our client's good character, and then the prosecutors will argue that that now they have open license to go ahead and talk about whatever it may be, dealing with the with the client. So for instance, let's look back at, at the case that I just mentioned, the Hasune case. In that case, what they wanted to do was present evidence of the client being a jokester, a prankster. That doesn't mean the government now can go ahead and bring evidence that the client is dishonest, or that the client is violent, or that the client is, is a drug addict or whatever. But oftentimes, and again, oftentimes that's because prosecutors don't care about the rules or don't know them, and oftentimes, judges don't know the rules, so they allow stuff like this. But nonetheless, it's gotta be the same pertinent trait, and that's something that we need to go ahead and ensure that a prosecutor doesn't get away with bringing in whatever it is that they want to bring in. So now, of course, another takeaway from this is that before we go ahead and present evidence of character, we gotta make sure that we know exactly what's out there. We need to make sure that we know that what it is that the prosecution is going to be able to go into. We really need to take an excruciating deep dive into our client's past, not just looking at convictions or that sort of thing, not just looking at arrests, but going beyond that. We need to really engage in a really candid and thorough discussion with our client that, bringing up, character, while it may appear to be certainly beneficial, that it has very significant downsides, and that we need to really worry about that. Because in a sense, what we're doing is that we're opening the door to the government bringing up character evidence, bad character evidence of our client. But again, it has to be the same character trait raised by the defendant, and the method of proving is through reputation and opinion testimony. As I mentioned before, those are the lead ways of proving character. And also, as I mentioned before, on cross-examination, the prosecutor may, be allowed to go ahead and get into specific instances of conduct. Remember that, the prosecutor has to have a good faith basis for that. Oftentimes, prosecutors will just make up this stuff from whole cloth. They have no good faith basis for it. You have the right to go ahead and press a prosecutor and force the court to go ahead and make the prosecutor tell you where it is that they're coming up with this stuff before the prosecutor engages in the cross-examination. Okay, now, so again, this is on the court's discretion. Prosecutor has to have a good faith basis, and the prosecutor is stuck with the witness's answer. If they get an answer they didn't like, too bad. They can't bring, extrinsic evidence to go ahead and cure the problem. They're stuck with the witness's answer. So far we covered the propensity prohibition. We talked also about how under the rule, under 404A, we have the right to go ahead and put at issue our client's character by bringing in evidence of our client's pertinent character trait. The second thing that we need to go ahead and take a look at is the victim's character. And this could be, very helpful. It's going to be very useful here. So what we have here is that that the rule also gives the defendant the right to offer up evidence of the victim's pertinent trait. So we have the right to go ahead and again bring in evidence of the defendant of the victim's pertinent trait. Now, the way we get to do that is through reputation and opinion testimony. Now, something that's critical to go ahead and note here is that the rule subjects to very strict limitations under Federal Rule of Evidence 412. We'll get to 412 shortly here. When it comes to the victim's predisposition or behavior in dealing with sexual conduct. So we'll talk about that. But again, that's a very important limitation on our right to get into the victim's character. Now, this is a great case here. And let me talk about this case here, which illustrates, how the right to go ahead and put in question the victim's character, how it plays out, how it comes, into play. And this case looks at different aspects or different issues that come up when we put, as a defense, we put the victim's character at issue here. So what happened here in the Kaiser case, this is a Ninth Circuit case, and is that in this case, the defendant was charged with shooting the victim and paralyzing the victim from the waist down. Now, what happened here is that the events here played out because of this party that was going on in front of the defendant's house, in front of Kaiser's house. So it was this party going on, and there were a ton of people, and the party was really loud, and what have you. And at the party, the defendant, got sick with the party. The defendant got sick of the fact that the party was so loud. So the defendant went to complain that the party was too loud and that they needed to go ahead and quiet down. When he got there, things got really rowdy, and he got rowdy. The people at the party got rowdy, and people started getting pushed, and a heated argument ensued, and the defendant ended up slapping a woman, and finally he left. But things, like I said, ended up getting kind of heated. So he goes home across the street. The party was across the street. It was across the street from the defendant's house. He goes home. He's visibly upset. His girlfriend is trying to calm him down. His girlfriend goes ahead and calls his brother, the defendant's brother, in the hopes that the brother can come and can calm down the defendant. The brother, in fact, calms down and tries to cool off the defendant. So at some point, the brother thinks that the defendant has cooled off a bit, and the brother decides, he can go ahead and take off, and he goes into his car. As the brother is, as the defendant's brother is sitting in his truck, then he is approached. This thing is a mess. He's approached by the brother of the woman that got slapped by the defendant at the party. So the brother of the defendant is approached by the brother of the woman that got slapped, and he comes. He's furious, and not only that, he's got two buddies of his, and he starts shoving the defendant's brother, who happens to be in his truck at this point, and you can see where things are headed at this point. So at this point, one of the two people that are accompanying the brother of the woman that got slapped, the brother of the woman who now is pushing and shoving the defendant's brother, and this guy goes to a car, and the defendant is watching all this, and the defendant sees this guy go into the car, and the defendant believes that he sees this guy go into the car and retrieving a firearm. The defendant at this point thinks that his brother is in danger. He picks up a rifle and shoots to a group of people where the group of people is at. And he ends up shooting the victim and ends up paralyzing the victim. Now, so the defendant ends up getting charged and going to trial. Now, what happened here in the interim is that the defendant who gets charged with assault resulting in serious bodily injury, at trial, he argues that he is justified in shooting in defense of his brother. And the defendant here tried to present evidence of actions of the victim that would go ahead and show that the victim is a violent individual. Now, remember, that we just talked about that a moment ago. Under the rule, under 404, despite the propensity prohibition, we have the right under 448(2) to present evidence of pertinent trait of the victim. So this is what the defendant is trying to do here, trying to present evidence of a pertinent trait. But the defendant is trying to do it by having testimony of an instance that happened at a court proceeding. This is involving this case, not at the trial, but at a court proceeding. What had happened is that the victim was present and the defendant's brother was present. And apparently the victim saw the defendant's brother and the victim started yelling and cursing and, making a scene, when he saw the victim's brother and acting in a very violent, very agitated, fashion. So the defendant wanted to present that evidence as evidence that would go ahead and show that in fact this individual was a violent individual. Now, so what the defendant wanted was evidence to show that that the defendant was a violent and aggressive individual. The defendant said, "Oh, this is irrelevant. This is and it's irrelevant." And this is the important part. It's irrelevant because the defendant didn't know this. The defendant didn't see it. The defendant didn't know about this. So this is irrelevant stuff. It doesn't really matter. Who cares whether something happened or didn't, or a relevant trait exists in the part of the victim if the defendant doesn't even know it? The district court, said, "Hey, that sounds like it makes sense to me," and the district court ends up excluding the evidence. So now the issue is on appeal. The case is on appeal, and let's see what the circuit does in this case. So again, let's remember what the government is saying is that, oh yeah, this here, what the defense is trying to bring in is irrelevant. I mean, the defense is trying to show that the victim is a bad guy, that the victim is a violent guy, that the victim is an aggressive guy, and they're trying to do that by showing that the victim had this aggressive, violent episode where he's yelling, he's cursing, he's doing it right outside of a courtroom, and he's doing it toward the defendant's brother. Okay, so that's basically what's going on. The government is saying that doesn't matter because the defendant, obviously that happened after the crime, that couldn't have influenced what the defendant was thinking about the victim. It wouldn't have influenced whether the defendant thought the victim was violent or not. So who cares about any of that? Well, and here's the interesting part about it. Now, the court says the very purpose of the character evidence is to suggest to the jury that the victim did in fact act in conformity with that violent character. So, the argument is, look, this guy acted this way, outside of that courtroom. He was very aggressive. He was very upset, acted very violent. This is somebody who's violent. There is a likelihood that this victim is going to have acted that way when he shot at when he was attacking the brother at the scene of the shooting, right as the party was going on. The circuit says it doesn't matter. It doesn't matter whether the defendant knew anything about the victim's character. It doesn't matter whether the defendant knew that the victim was violent or not. That's immaterial. The rule permits character evidence that shows that there is a propensity, indeed, that the victim would have acted violently on say the time of the crime. The problem, however, was not with that. So the problem wasn't really the argument presented by the government. The problem was that the defense could have presented evidence of the defendant's violent character, but it needed to be through reputation or opinion evidence. In this case, the defendant tried to do it with a specific instance of conduct and tried to do it through extrinsic evidence, and that is not permitted. So I like this case because it illustrates a bunch of different points. First of all, obviously, it states the obvious point that we have the right to put the character of the victim at issue. In this case, the character was one of violence. The argument is that the victim is a violent individual, that it is likely that when he was confronting the defendant's brother, that he was indeed going to act in a violent way, and that's something that the jury has the right to go ahead and hear. The jury, the evidence, however, has to come in through opinion or reputation evidence, not through specific instances of conduct, like what the defendant wanted to do here. In this case, the defendant wanted to do it through an example, the example of this scene that took place outside of the courtroom. So again, the takeaway here is that while it doesn't matter whether the defendant knew or didn't know about the victim's character for the evidence to come in under this rule, what matters is the manner, the form of the evidence that we're presenting. The critical thing is that we present character evidence that is in the right form. Now, parenthetically, having said that, if, for instance, what we would have had here is a situation where, let's say the defendant would have known this individual. Let's say that the defendant would have known that this was a violent individual. Then, let's say that the defendant would have seen the individual acting out in a violent fashion. And at that point, then he could have argued that that would have buttressed the reasonableness of a defense of others claim. Okay, so it would have come in for another reason. It would not have come in as character evidence of the victim under 404A. Instead, it would have come in as evidence showing the reasonableness of the defendant's belief in that this individual was indeed a violent individual, and that the defendant, needed to go ahead and take steps to defend his brother. But again, as far as the specific act, it could have come under that theory, but it could not have come in the way that the defendant wanted to show it in this case. And in this case, the defendant, it seems, really didn't know about this particular individual, so it could not have come in under that particular way. Now, if we present evidence, going back here to our PowerPoint, and again, thanks to all of you for joining me today. Certainly don't hesitate to go ahead and either ask any questions, or if you want to go ahead and email me and you want to go ahead and talk about anything that we covered today, or if you want to brainstorm a case or whatever, don't hesitate to go ahead and do it. This stuff here it's really not rocket science, but there's a lot of pitfalls here, and there's a lot of tricks to this that we just really need to be very mindful of. Now, if we, the defense, presents evidence of the victim's of a victim's character trait, then the prosecution, under the rule, under 4.4a, the prosecution gets to go ahead and rebut it. And they get to rebut it in two different ways. And this is why all this stuff is so dangerous. And this is why, it's something where we need to be very careful in selecting how we're going to play this out. So we really need to be making very careful, tactical, and strategical decisions as to where we're headed with our defense, because again, there's a lot of tripwires here. So if we raise the issue of character, of the victim's character, and we already saw that we have the right to do that if it's a pertinent character trait, then the prosecution can rebut that. And the prosecution, again, can do it in two ways. The first way is that the prosecution can offer evidence of the victim's pertinent good trait, and also the prosecution can offer evidence of the defendant's same trait. And that's the key, because oftentimes what you see in this kind of cases is that the defense presents evidence of the victim's character, thereby opening the door to the government rebutting under this rule. And then the prosecution feels, and oftentimes the judge will go ahead and go with it, is that at that point the door is wide open, that anything can come in. So say going back to the case we just talked about, and the shooting, the Kaiser case, so the defense brings in, let's say, evidence of violence in the part of the victim. Then the prosecution not only will go ahead and bring evidence in the part of the victim that the victim is peaceful, but that the victim is honest, that the victim is a good husband, the victim is a good father, that the victim is a religious man, and so on and so forth. And you see that happen time and time again. The evidence has to match. It's got to match what we initially brought forth. And it's got to be a pertinent trait. And again, it's got to go ahead, and it's got to be not any other trait, any trait. It's got to be limited to the trait that we raise. But then again, the other dangerous part is that once we raise this, the prosecution gets to offer evidence of the defendant's same trait. This is something that we have to be very careful about, because what happens here is that, again, going back to the Kaiser case, let's say that in Kaiser, they would have been able to present the evidence of violence in the part, violent character in the part of the victim. So if they're able to go ahead and do that, then not only would the prosecution be able to go ahead and show evidence of the victim's good character trait, they can also show evidence of bad trait in the part of the defendant. Obviously, something that can be highly dangerous. So, again, before you go down that route, before you take this path of showing character evidence on the part of the victim, be very careful. Now, I do want to emphasize that, again, showing evidence of the character of the victim in this context is different from showing evidence of, say, the reasonableness of the defendant's belief and the need to defend himself or his brother and that sort of thing. That is a different analysis. It is not done under this rule. It's just simply done under, the defense of self-defense or defense of others. Now, so, if the prosecution gets to rebut, again, the rebuttal has to be through reputation or opinion evidence and cross-examination. They may be allowed to present evidence of specific or cross-examine on evidence of specific instances of the witnesses, or excuse me, of the defendant's conduct. Or in this case, it would be the victim's conduct, excuse me. But remember that, first of all, the court has to allow it. The prosecution has to have a good faith for it. And the prosecution is stuck with whatever answer is presented. Now, if the prosecution presents evidence to rebut our evidence of character, we get to cross-examine, and the same rules apply. But then at that point, we get to cross-examine whatever evidence, whatever witness the prosecution presented regarding, say, the good character of the victim. Okay. Now, this is another area that bears to mentioning, and that is that in a homicide case, if we make the argument that the victim was the first aggressor, the prosecution gets to present evidence that the victim's trait for peacefulness, and they got to do that through reputation or opinion testimony. So, for me, it's amazing how a relatively small rule 4.4a can have so much stuff packed into it that really materially impacts our clients. Okay, now let's go ahead then and shift gears here. And then we're talking so far, of course, about victim's character, but here we're going to be talking about a very important limitation on the right of the defendant to present evidence of the victim's character, and that is in sex cases. So in sex cases, the federal rule of evidence 412 prohibits evidence that the victim engaged in other sexual behavior or of the victim's sexual predisposition. This is a really broad rule, as we'll talk about in just one moment. The rule, however, creates three important exceptions for us, and one is the source of semen injury or other physical evidence was another person other than the defendant. The second, part of the rule allows for instances of prior consent. If the defendant is arguing that no, this was a consensual encounter, and then lastly, and those instances where it would violate the defendant's constitutional rights. Now, also the rule has very rigid procedures for admissibility, and if we screw up in that, the courts are unforgiving. Okay, courts are very unforgiving, and there's case after case where we didn't file the admissibility procedures to show that we fall under one of those three exceptions, and courts routinely just basically deny our ability to go ahead and bring evidence that would arguably qualify under this exception because we failed to follow the procedures of admissibility under the rule. Now, I mentioned that the limitations on the presentation of sexual behavior are very broad under the rule. And I'll give you a couple of examples here. But any evidence of physical sexual conduct, such things as, for instance, use of contraceptives, and the way that the victim dresses, their lifestyle, speech, and all that, anything that can be construed as being sexual behavior is essentially off limits. It's a very broad rule, a rule that does not favor our side. It very clearly favors the prosecution. Now, so for instance, let me give you two examples here. The Withorn case. In that case, what happened here is that the defendant was charged with beating and raping a 12-year-old. The defendant tried to introduce evidence of a prior accusation by the victim of another individual. That individual happened to be a friend of the defendant's. That individual actually ended up committing suicide based upon the allegation of that same victim. And what the defendant wanted to do was to show that oh no, this victim goes around making allegations like this and that sort of thing. The district court prohibited the defendant from presenting that evidence, and of course the defendant agreed on appeal that was error. And the circuit, however, concluded that that was evidence that would be barred by Rule 412 because these allegations and what have you do have to do, or they have to deal with allow me to go ahead and go back to the rule with sexual behavior. So again, sexual behavior under rule is giving a very broad definition. Another important example of that is the second example I got there. And of course, in my book, I have many, many examples of this and how courts play all this out. In the Papaki case, what happened is that the defendant was charged with sexual abuse. The defendant tried to introduce evidence that the victim told. This is as the deputy was interviewing the victim about the sexual abuse allegedly committed by the defendant. The victim was proposing to the deputy. The victim was telling the deputy that he was cute, that she wanted to jump in bed with him, and all this. The defendant was saying, hey, this is important evidence, it's relevant evidence, it's evidence that shows that, probably the sexual abuse didn't even occurred because, a normal person would not have been approaching the deputy under the circumstances when the deputy is questioning the person about the sexual abuse, supposedly shortly after the sexual abuse occurred. The district court excluded the statements, and the circuit upheld the exclusion. The circuit basically said that the evidence was properly excluded, that the rule excludes sexual behavior, and that sexual behavior is not limited to sexual contact, intercourse, and that sort of thing. That behavior can include such things as speech, behavior, even fantasy. So the proposition that the victim had to the deputy, I'd like to jump in bed with you, as the deputy was questioning the victim, that would have been covered. Now, so let's go into the actual exceptions. We already talked about the fact that that Federal Rule of Evidence 412 imposes very strict exceptions and getting into the victim's sexual behavior. So if we want to get into the victim's character, but if the character has to do with sexual behavior, then we're really hamstrung. But we do have certain areas we can get in, and this is one. This is one of the exceptions. That another person was a source of semen injury or another or other physical evidence. And this is a great case on this Bear Stop, the case of Bear Stop. Here what happened is that the defendant was charged with aggravated sexual abuse of the victim. The victim was a 6-year-old child. at trial, the government presented evidence that the child presented symptoms consistent with a child that had been abused. So the government presented evidence through psychologists and school counselors that the child experienced bedwetting, hyperactivity, nightmares, aggressiveness, etc., and that all those behaviors supposedly were the result or were consistent at least with sexual abuse. Now, the defendant wanted to go ahead and introduce evidence that other individuals had sexually abused this victim. Specifically, the defendant wanted to introduce evidence that that several boys had sexually abused this victim, this child victim, and that he had been sexually assaulted by a couple of boys. This would have been somewhat contemporaneous with the alleged assault on the part of the defendant. And the evidence was presented to go ahead and provide an alternative explanation for the characteristics that the psychologists, the counselors, and all had testified to, and in addition to challenge forensic evidence, specifically bloody underwear that the victim had. So very important evidence in the part of the defendant. The court, however, the district court excluded the evidence. Fortunately, the defense had engaged in a very aggressive proffer, had clearly proffered everything. The record was an excellent record. The circuit court, in this case, the Eighth Circuit, after looking at the proffer, concluded that the district court abused its discretion and that the evidence about the boy, the victim, being assaulted should have come in at trial. Here, the evidence was offered to provide an alternative explanation for the victim's behavior and the manifestations that would have been consistent with everything that, again, the psychologist that the government presented testified to, the bedwetting, aggressiveness, inattentiveness, hyperactivity, etc., that the psychologist said those were consistent with being sexually assaulted. So that is an important exception, and this case is a great example. And as I mentioned before, these cases are all summarized in the defender's guide in my book. Now, another important exception, is consent. And there's a great case on that. The Begay case is another Begay case. Here, what happened is that the defendant was charged with sexual abuse of his second cousin. The defendant filed a motion seeking the admission of specific instances of sexual encounters, specific instances of sexual encounter between him and the victim to show consent. All this happened at the district court level. Here, the district court, after a hearing, allowed the evidence, the defense counsel here proffered evidence of numerous specific instances of consensual sexual encounters spanning the period of 2 years. And here the district court did grant the defendant's motion, saying that this is clear evidence of consent that would clearly qualify under the consent exception to the prohibition of 412, Federal Rule of Evidence 412. Another important exception is evidence whose exclusion would violate the defendant's rights. I made a mistake. I told you that was the prior case was another Begay. This is the other Begay case. It's this Begay case as well as the other one. The other one was not Begay, it was Bear Stops. My mistake. And of course, this PowerPoint can certainly be made available to you. You can have the PowerPoint, and you can contact me if you have any questions about it. But here, what happened is that in this one here, the defendant was charged with aggravated sexual abuse. A doctor testified that it was impossible to determine whether the victim's symptoms reflected one violent sexual penetration or repeated penetrations, but the trial court precluded the defense from presenting testimony that on 3 separate occasions in the summer, another man had assaulted the victim. The district court precluded that using the prohibition on the 412. Now, the Court of Appeals concluded that the trial court erred that in this case, the defendant's right to confrontation was at stake, and that the defendant had the right to go ahead and confront the victim, and consequently, this case fell under 412B1C. That is the exception that deals with evidence whose exclusion would violate defendant's right. Excellent case, in the right case if you had it. Okay, now I mentioned that there's very rigid steps for admissibility if we're trying to bring in evidence that may fit under any of the 3 exceptions to 412. Again, that being evidence whose exclusion violates the defendant's rights, consent, or that there's another individual that could be a source of semen, injury, or other physical evidence. If you're trying to bring in evidence under those exceptions, any of those exceptions, there's very rigid admissibility procedures that you gotta follow, and courts are, as I said, unforgiving. So here, you gotta go ahead and file a motion describing the evidence. You gotta do it before 14 days before. You gotta serve the motion on all parties. You gotta notify the victim or the victim's guardian or representative. The court has to conduct an in-camera hearing, and the hearing has to go ahead and be sealed. And if you don't follow those steps, the court is going to go ahead and exclude it. The Seymour case is a great example of, not a great example, a terrible example of exclusion where the defendant failed to go ahead and follow the admissibility requirements. But there's case after case like this one. In the Seymour case, the defendant was arguing that there was an exclusion to a rule because he was trying to bring in evidence, present evidence at trial that the contact was a consensual contact with the victim. So, as we're approaching time here, let me go back to my roadmap. Today, we covered the propensity prohibition, methods of proving character, exceptions to the propensity prohibition when it comes to the defendant and the victim, and what the government can go ahead and do in rebuttal. We also talk about the important exception to the exception of the presenting evidence regarding the victim when it comes to evidence of sexual conduct or behavior under Rule 412. Next week, we're going to be talking about the critical topics of character of the witness, and that is truthfulness that drives that. In addition to that, we're going to go ahead and be talking about other crimes and wrongs under 404B, a critical rule for us as a defense. That's probably one of the worst rules for us. At the same time, we're going to talk about how we can use that rule in our favor. And in addition, we're going to also be talking about the terrible rules for the defense in 413 and 414 of our rules of evidence and similar crimes in sexual assault or child molestation cases. So, I really hope that you can join me next time. Should you have any questions at all, if you want to go ahead and again brainstorm anything that I discussed, don't hesitate to go ahead and just reach out to me. Let me go ahead and again share with you my my email. if you want to touch base, again, on a case or whatever, don't hesitate to go ahead and email me. I'll be happy to go ahead and do it. Sometimes I give a presentation. For instance, I gave a presentation at the beginning of this year, and yesterday I heard from a kind listener that heard my presentation, and they want to brainstorm their case. So we set a Zoom meeting for next week to talk about the case. So it's a pleasure and an honor to be with you. Of course, this matter is covered at length in my book. And again, as I said, all royalties go to NACTO's Foundation for Criminal Justice, a good, a very excellent, charity. Thank you so much for everything that you do. You are the true defenders of liberty. You're there in the front lines. Much admiration and respect to all of you. And if there's anything I can do for anybody here in Las Vegas, if you need anything in Las Vegas, don't hesitate to go ahead and join me. So thank you very much. And thanks a million to you, Vanessa, for everything.
Well, thank you so much, Rene, for an incredible presentation.